Blog Talk Radio.
All right, good evening, folks. This is Law for Dummies. Tonight we're talking about due process of law. We do have Ted Fogg with us in and out tonight. He's actually recording the show and kind of helping me promote this show, so we need to get this out there a little more. I guess the first thing I'd like to start with is naming what is due process. Due process of law. Black's Law actually defines it as the law of the land, because it is the law of the land. And not many people explain this the way I do, apparently, according to a man that's been in law for 61 years, and that is, it is a process that is due to you as a human being. This falls under fundamental rights as a natural right, the law of the land, and actually further is supreme law of the land, as it is in the Constitution as due process. So this is a process. There's always a process that is due to you as a human being. And anytime that process is not adhered to, well, that would be a violation of due process. And part of due process is making claims or assertions that those rights have been violated. And there are numerous rights within due process, and that's part of what I'm going to be going over. And this may turn into like a three-part educational series, because there's different aspects to due process of law. You have criminal law, you have civil law, and you have federal law. So you have the state side and you have the federal side. And I don't know, there's certain parts of the law that says, oh, well, only federal law applies in the federal courts. It doesn't apply to the states. But yet, it's all supposed to be one law of the land. And so I have a hard time believing that something that's in the what's called federal Constitution doesn't apply to the states, because the Constitution was created by we the people. I mean, the preamble itself, the first three words in the preamble to the Constitution is we the people. And the thing is we the people instituted government for the protection of our rights and to ensure justice. And we don't seem to be having that going on these days. And I think mostly due to lack of education on what is actually supposed to happen. What is this process? How are you supposed to be treated in accordance with the law? So I'm going to try and go through this. I have a treaty on arrests and false imprisonment that I'm going to be reading from, because it's loaded with some really, really great stuff. And this is written by Charles A. Wiseman. This is in Kirk's Law Corner in the private group. Downloadable as PDF in the files section. If you're not a member of Kirk's Law Corner group, then you may want to seek that out and get in there, because there's some great information in there that I post in there from time to time. And I keep it a private group just to keep things on the down low, so to speak. But I do want to take a little time here and give thanks to our sponsors, Brian Kinter, Neil Shelton, Randy Davis, and Cheyenne Davis. They're doing some awesome work on this very same network, Future of Our Children. They each have their own shows. There's a few other shows. One to be tuning into probably tomorrow night is Jay Moss and Bud Vino with the Far From Normal show. They have Chris Hallett, who's got a case that's articles of impeachment that's in front of Congress. And it's dealing with the Bar Association and trying to basically claiming there's a monopoly there. So I'm going to try, and I probably won't be able to actually listen too much or anything tomorrow night because I have my sons on Tuesday nights exactly at that time. So it makes it difficult to listen to that when I only have 2 hours with my son. So I try to pay attention to my son. Anyway, so when we talk about law, we have to understand what law is first. And I have a published booklet here. This is published by our Secretary of the State for Boise, Idaho. It's 2017 edition. You can go down to the Secretary of State and pick one of these up. And on the cover, it says Idaho State Constitution, Declaration of Independence, and the United States Constitution. Now, that's law. Statutes, rules, regulations are not law. So when I talk about law with a capital L, this is what I'm talking about, law. Because, I mean, there's several cases out there, and I already know this. I don't need case law to tell me this, but, you know, the code is to codify the law. It is not to be law, and it most definitely does not have the force of law because it's not law, contrary to the most popular belief that the code is the law and that administrative rules or administrative law is law. No, it's not. And we need to actually read what the law says because we're being duped. We're being duped into believing that, well, the statute says, the code says, well, great. What does the law say? Because that's the most important part. The law, not what some legislator does, and those bills that they pass creating acts. They don't have the power to make law. Another contrary to popular belief is they don't have the power to make law. We, the people, are the sole arbiter of law. We make law, not government. Now, there is delegation of authority within the Constitution for the federal government to make law. We did delegate power to the federal government, but it's very, very limited in what those the subject matter is of that delegation of authority. And most important part of it is all things foreign commerce. If you read the Constitution, it specifically says to make all laws regarding commerce, and it's between a foreign country and the United States and a state, or between a state and another state. Not between man and man. We're talking corporations. Now, I'm not going to get off into all the other stuff that goes along with how we've been dubbed a person, a corporation, because that's what a person is. We, the people, are not persons. We're not artificial people, artificial persons. That's what a person is. So, all right. So, part of the law of the land is, you know, in the Bill of Rights there, but there's much more to it than that. Let's go read our Bill of Rights. Most people know, well, I won't say most people know because I don't know if most people actually know that, so I can't confirm that for sure. But we have what's called the Bill of Rights. And let's see. Opening up my book here. Oh, where are they? All right, okay. Oh, no wonder I'm looking in the state of Idaho. So in our Bill of Rights, a lot of people know the First Amendment. Religious and political freedom. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. That's not necessarily due process, but it does stipulate in there that Congress shall make no law respecting an establishment of religion. So you can establish your religion how you see fit. And they can't prohibit the free exercise thereof. So a lot of times you can claim a religious protection when you go through your due process part. Second Amendment, the right to bear arms, well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. I have a hard time with understanding how people don't understand the word infringe. But I'm going to skip to number 4, because number 4 is actually kind of what I'll be covering, is the right to be secure. The right of the people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Why does it say shall not be violated? Because it's not authorized. It is not authorized by government to violate these rights, violate due process. And no warrants shall issue. Wonder why it says no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized, which is odd that they actually use persons and not people, but there again, our system of government over time has changed the actual definitions of these words. So we have to be real careful what words we do use, because they mean something totally different in court than they do out here on the street, what I call slang. What we think something means out here on the street is not what it really means in law or in court. So, on that, in this treatise on arrests, arrest without a warrant, the law of the land, the authority to arrest without warrant was rather limited and well defined at common law, a law which has been made part of our constitutional law in the due process provisions. The common law rule on arrest is based on experience and common sense. Imagine that. Common sense, have a little common sense here, folks, is a general rule at the common law, and arrest cannot be made without a warrant. Thus, the right to arrest a person without a warrant is an exception to the general rule. This simple rule was expressed by Justice Carpenter in delivering an opinion for the Supreme Court of Michigan as follows. The law governing this case is elementary, except for a breach of the peace committed in his presence. That's having actual first-hand knowledge, or when he has reasonable ground to believe that the person arrested is a felon or is about to commit a felony. A police officer has no authority to arrest without a warrant. That's Cook versus Hastings, 150, Michigan, 289. That's from 1907. Now, you can't get much more common sense than that. We can't delegate an authority or a power to someone else that we do not possess ourselves first. So, with that being said, we can't make an arrest without a warrant unless it's happening directly in front of us. And to explain the whole breach of the peace, well, we'll go into that here shortly. The object in this law was to have a balance between preserving liberty and preserving the peace. Those who committed the most heinous crimes, that being felonies, were a threat to the safety of society and could be summarily deprived of their liberty by arrest. Those committing a breach of the peace could also be summarily arrested, not for apprehension as a criminal, but to preserve the peace. But for other offenses, summary arrests had to yield to the liberty of the citizen. The liberty of citizens is too sacred to be left to the arbitrary will of men. Everyone knows what felonies are. The most common felonies are murder, rape, kidnapping, sodomy, armed robbery, abortion, pedophilia, treason, and arson. A breach of the peace is also obvious and well known. Therefore, everyone's liberty was safe, since all knew for what reason they could or could not be arrested. But where is the safety in one's liberty if they are to be subject to every ordinance or law that legislative bodies may choose to enact, or if the law on arrests can be changed by statutes, which I'll need to find it in here, but this is the thing we need to understand about due process of law being the law of the land. There is no authority to make a process through statutory law, because it's the law of the land, and statutes are not law of the land. Constitutions, the Declaration of Independence, the Virginia Declaration of Rights, the Magna Carta, those are law of the land. That's law that we, the people, have laid down, ordained, and established as law. And when I come across that, I'll go over that part. But the breach of the peace part, it has to do with violence. So if two people are arguing loudly and starting to react with each other violently, then that is a breach of the peace, because people are getting concerned. Let's say it's in a bar and they're starting to, exchange words and argument and getting loud and disrupting the peace within the bar. Now, somebody can actually make an arrest for that while it's happening. But if somebody were to call the police, and even if the guys get into a scuffle, end up shaking hands, sitting down at the bar, decide to have a beer anyway, become friends, whatever, and the officer comes rolling in, the officer cannot make an arrest without a warrant, because he does not have firsthand knowledge that it happened. But we see today, all the time, you'll have a domestic dispute at home, and the police will get called, and somebody's going to jail. Most of the time, it's the man. It's funny, even if he's not the one that started it, even if he's not the one that caused injury or harm, it seems like that the man is always the one that goes to jail. But no, that is a violation of due process of law, because you don't have a warrant. You don't have a warrant to make the arrest, because the executive branch in and of itself, due to separations of power, don't have the power to issue warrants. Warrants comes from the judicial branch. That's why the judicial branch is the one that issues warrants, and the executive branch is the one that executes those warrants. Due to separations of power, they're not supposed to act on their own unless, again, it is a felony that is happening directly in front of them. They have to have firsthand knowledge that this has happened, and then they have to file their affidavit, signed and sworn under penalty of perjury, because that's what the law of the land says for the Fourth Amendment. And there's law that's backdated from the Virginia Declaration of Rights clear back to the Magna Carta of 1215 and the 1225 reissue. So, that's another thing is those documents are part of the supreme law of the land. because that is law that we have laid down, ordained, and established as law. And those are rights. Most of those are rights, and rights carry forward through succession of law. So if we have a right that's been declared in the Magna Carta of 1215, that right cannot be diminished through succession of law. So we need that's the big thing that people need to understand is no, you don't get to change how the right works. Once it's been established, that's it. That is the right. And the rights are law. Okay, so let's see. By the Due Process Clause, and not the 14th Amendment, we're talking about the 5th, the common law governs what the law on arrest is in this land, and where it exists, the most statutes can be is declaratory of the common law. If there is no direct language in the Constitution directing what procedure or process is to be followed, the common law is to be the due process of law followed, not a legislative statute or city ordinance. There it is, right there. Officers who do not abide by this law are trespassers and are guilty of false imprisonment. So we all understand that? That if it's not in the Constitution, if there is no direct language in the Constitution, this would be a state constitution, directing what procedure or process is to be followed, the common law is to be the due process of law followed, not a legislative statute or city ordinance. So in this particular subject matter of due process of law, there is no legislative authority, period. It's in the Constitution because it has to be law of the land. And again, statutes are not law. The following is some material to help the citizen in protecting his liberty from unlawful encroachment by executive officers. First, to initiate a suit against one who unlawfully deprives you of your liberty, there is an example of a summons and a complaint which need to be served upon the defendant and the court. There is also a memorandum of law on the subject of arrest without a warrant, which is legal proof of the law that has existed for hundreds of years on this matter. Now, all of those things are included in this treaty right here. Excuse me. I'm looking at the paperwork. It shows you how to lay it all out, how to do your counts. Here's the memorandum of law on arrest without warrant. Now we have case law that basically says any man who violates this common sense law of the land will suffer at their own peril. So keep that in mind. That's part of due process of law. Due process of law goes all the way to the Supreme Court of your state. Okay? Due process of law doesn't stop at the first court you go into. So one thing I really like about this treaties on arrest and false imprisonment is it actually has an Idaho case in it. In describing false imprisonment as being the unlawful restraint of the liberty of a citizen or of the primary right of freedom of locomotion, the Supreme Court of Idaho also stated, imprisonment is any restraint of the personal liberty of another and prevention of his movements from place to place, or his free action according to his own pleasure and will. It is false imprisonment when this is done without lawful authority. That is Griffin versus Clark, 55, Idaho, 364. There's also Cordell versus Standard Oil Company, Johnson versus Tompkins. So even just the slightest bit of deprivation of the right of liberty is a false imprisonment. So, officer walks up to you and says, "Hey, what are you doing?" Well, do you have a warrant? Because if you don't have a warrant, you better have lawful authority to even stop me from exercising my right of liberty. Am I free to go? If I'm not free to go, you better have a warrant. Unless you're accusing me or have articulable and reasonable suspicion that I have committed a crime that is an arrestable offense without a warrant. And we just went over that. It must be a felony happening directly in front of him. You're in the middle of robbing a bank and the cops show up, that's happening directly in front of them. Yes, they can make an arrest without a warrant because that is a felony happening directly in front of them. But you walking down the street and an officer depriving you of your right of liberty is not. That is an imprisonment. False imprisonment. Let's see if we got. All right, we do have somebody here with a question. 7731. Who are we talking to?
Your favorite Monday evening person, Crystal.
Who are you again?
You know that one weird woman in Utah?
Weird? Weird woman. I don't know. Define weird because I think you're a pretty neat lady.
Abby Normal?
Again,
better.
Define that one. We can spend all night on that. So
right.
Did you have a question?
As soon as I do. So false imprisonment. Okay, so let's say, for an example, a policeman comes to your house and wants to ask you questions or wants you to make a statement. Would that be considered a false imprisonment, or would it just be them stopping you and asking you what you're doing?
Well, first of all, he's from the executive branch.
Right.
And they do have power to do investigations and that kind of stuff. But they have to have a proper delegation of authority because that would be trespassing. Can I come onto your property without your permission?
No.
No. So neither can an officer in uniform. That's the thing we need to understand is they're agents. They're agents of the executive branch. And an agent can only act on behalf of another man. And then only perform the duties that same man can do. They cannot do anything that I can't do. Right. I can't delegate an authority to them to go to your house and harass you, trespass and harass you, because I can't do that. That's trespassing. And when an officer does it, and he has a gun on him, and he's acting outside of his ministerial duties, that is a crime.
Right.
That is felony.
So how would you...
I don't know if it would be felony. It could be construed as felony.
So how would you prosecute that? How would you prosecute that? Or go after him for it?
It's pretty
file
simple.
A complaint?
Yep.
Who would you file a complaint with?
And actually, most of the time, they won't even take your complaint.
Right.
But you can go. You can. There's videos out there to show you how to make your complaints and all that stuff, so that they're really good.
So would you go outside of your jurisdiction to do it? So would you go outside your jurisdiction?
The jurisdiction is where it happened. Well, part of the jurisdiction.
Right.
But if you were to claim false imprisonment, that would have to do with civil rights, so you could automatically take that into federal court.
Right.
Because it is a civil rights violation.
Oh, now, absolutely.
If the officer comes onto your property, he does not have a proper delegation of authority. He knocks on your door, and you say, "Who is it?" Well, I'm Officer John Doe with such and such police department, and I need to ask you some questions. and you can speak through the door. You don't have to open the door, and say, "Sir, I'm going to need to ask you to leave my property." Now, they have 4 seconds to make movement towards leaving your property. This is part of giving notice that they are trespassing.
Okay.
And they have to leave. Unless they have a warrant describing the person, the place, or thing to be searched or seized, they have
kind of
no
like that
proper
nurse case here in
delegation of
Utah.
authority to be there.
Right, where that nurse was harassed by the officer, and when she asked him, "Is he a suspect? Do you have a warrant? Do you have this?" And she was arrested for upholding that gentleman's constitutional rights, or his civil rights.
She wasn't arrested; she was kidnapped.
Right,
because an arrest involves proper delegation of authority, and there was no felony committed directly in front of him, so he had no lawful authority to make an arrest without a warrant, which is what I talk about acting outside of your ministerial duties. As the executive branch, you're supposed to execute what the judicial branch gives the sheriff's department, and everything goes through the sheriff's department. The sheriff is the one that delegates the warrant to either their own deputies or the municipal branch, whatever the sheriff decides.
Right.
And sometimes the warrant will actually be given to a certain, or addressed to a certain municipal deal, but it still has to go through the sheriff, because the sheriff is the high executor of the county.
Right.
He is the highest law enforcement man in the county.
So I would say, okay, so like you have a city police, right? So the county sheriffs would be above them, correct?
Oh, yes.
Is that okay? And then above them would be like the highway, in Utah would be like the Utah Highway Patrol would be above them.
No.
No?
The sheriff is the highest lawman in the county.
Oh,
Our states are broke up into counties for a reason.
Right.
State police aren't really. They're for freeways.
Right.
Interstate.
Okay. Right. The Utah Highway. Highway.
They're not. Yes, streets and highways. They're actually the ones that's supposed to take care of people acting in commerce on the streets and highways.
Okay.
Not
So then above them, I guess I would say the FBI would be above them? Above the sheriff?
There is no man. No? There is no man higher than the sheriff.
Okay.
The federal government, the military, FBI, CIA, I don't care what alphabet soup branch they think that they're from,
bows down to them.
There is no higher authority than the sheriff.
Oh, none. Okay.
None.
Gotcha.
Even the military is supposed to be amenable to the civil authority, and that would be the sheriff.
Right. Okay, that makes more sense now. Okay, got it. Okay, because that's what I was trying to figure out is who has what jurisdiction, and that's the one thing I couldn't quite grasp my head around is who has. So basically, in the state, the sheriff's department has the highest power. Would they be under the Secret Service?
If you have a problem with a municipal police officer, he's not even a police officer. He's supposed to be a peace officer, keeping the peace.
Right.
You can actually contact the sheriff's department and make your complaint with the sheriff's department that this officer or this municipal peace officer or this municipal organization, because it is a corporation, is acting outside of their scope and authority.
Okay. Okay, that's what I thought. I just wanted to verify that what I was thinking was true and correct.
Right.
So I am right. Okay. What I thought. Okay. Sounds good. Nothing new on my federal, by the way. So We're still in the holding pattern for 2 weeks now, so I know, right?
Oh, the stalling pattern.
Well, but that's a good thing, though. Because remember, we're waiting for her to decide on motions to dismiss. So the longer they hold out, the better it is for us. So, as a plaintiff.
It's a pretty standard procedure.
Uh-huh. Yep.
When somebody like us files a suit, the state or whoever that's the defendant will automatically do a Rule 12B. It's
all 8 of them did.
Yeah. And so, I mean, let's take that into consideration, because part of due process of law is raising objections to jurisdiction, which is the first thing. And this is a prime example of due process, because they do it every single time, whether they have truth, facts, and evidence to back up their claims or not. And it's always a claim of jurisdiction.
Right.
Most of the time, it's personal jurisdiction.
Right.
So, what we try to do here is reverse that and use the same tactics that they use, because they already know the process. They already know due process.
Right.
And that's exactly what we need to do. That is the first thing. Before you file anything, before you make any kind of pleading, that is part of due process, the very first thing that needs to be done.
Yep.
So at a state level, let's say you get an officer comes to your house, they arrest you. Let's just go with an actual warrant. Let's go without the warrant, because this actually happens a lot.
Right.
And again, I'm going to actually give this disclaimer again, is I am not an attorney. I'm not licensed to practice law. I wouldn't even know where to get that license that they claim that we're supposed to have. And this
there's no license. It's a bar card.
For educational purposes only.
Right. So just to let you know, a little funny disclaimer about a bar card member is they actually will tell you that they just have a private membership in like a club, is what they'll tell you what their bar card stands for.
Right. Oh, yeah.
Okay, but go ahead.
It's a membership.
Yeah.
Yeah.
That's all it is. It's not a license. They do not have a license to practice law. There's no such thing as a licensed attorney.
No.
So, okay. So go ahead with your warrant. Sorry.
It's a state bar corporation. It's not actually the state.
No.
Bar. It's a corporation. It's a private corporation.
Right.
Like
it's a private entity.
How about the National Rifle Association? Do they have the power to issue licenses?
No. It's a membership in an organization. Correct.
Technically, only the state itself has the power to issue licenses.
Right.
And not any sub-corporation. So, when you go to apply for a business license, the state issues a business license.
Right.
But the state doesn't issue a license to practice law. The Bar Association does. But it's not a license, it's a membership.
It's a membership in their club.
Correct.
Yep. Okay, so sorry about that. So go back to your warrant. Sorry about that. That was totally off topic.
No worries. So part of the due process here, if an officer makes an arrest without a warrant, obviously there's a jurisdiction issue, because there was no lawful authority, no delegation of lawful authority to make that arrest without a warrant. So according to the rules of procedure, you make a motion for dismissal with prejudice for lack of jurisdiction for failure to state a cause of action for which relief can be granted. Because you can't grant relief or an award to somebody who doesn't have a right to a cause of action. Because that's how all cases are supposed to start. The very first thing that's supposed to be done in every case is an affidavit signed, an affidavit of truth signed under penalty of perjury. declaring this has happened to me and this is how my rights were violated. This has to be done in writing, and this is part of what is supposed to be showed to you when you first go to court, your initial appearance. That affidavit of truth is supposed to be laid before the court, and it's supposed to make a determination whether it's actually probable cause is actually what they call it now. And what it is a right to a cause of action. Because a cause of action, you have to claim that one of your rights has been violated and you have been injured, or this person has caused harm to you. This is the first step of due process of law.
Right.
That affidavit is key. Now, I want people to understand that if this process is not followed to the T, they lose all jurisdiction, which is exactly why when you attack these other people, they file the Rule 12b to try and dismiss for lack of jurisdiction. And so, again, trying to flip this around and do the same exact thing in every single case. I don't care if it's criminal or civil, family court, whatever. There is no jurisdiction unless someone can claim that right has been violated and what right it is.
Right.
So that is the first thing you file. You file your motion for dismissal, and the first time you go into court under your initial appearance, your paperwork's already filed. And I'm here to go, well, we're dismissing this right here, right now, unless the moving party can prove that they have a right to a cause of action.
Right.
Or that this is the proper venue for this.
Right.
You know, and everything like contempt of court. Those are criminal in nature, not civil in nature. They're criminal in nature. So when you go into your family courts for this contempt of court, you could automatically make a motion for dismissal with prejudice for lack of jurisdiction for failure to state a cause of action for which relief can be granted, because this court is not a competent court to hear the subject matter. That's subject matter jurisdiction. And even in my rules of procedure for family court, the rule number 101, the scope and authority of the family court, specifically says, blah, 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 except for contempt of court.
Right.
This court does not have competent jurisdiction to hear the subject matter jurisdiction of contempt of court. But yet, all across the land, I hear it all the time. Oh, I just got contempt of court. I just got contempt of court. Did you make your motion for dismissal? No. No, you didn't.
Right.
Now, motions can be made orally, but you have to follow the motion practice. Now, in this state, they say it's you have to make your claim, your motion for dismissal, then you have to claim your grounds for lack of jurisdiction, and then they say pursuant to what rule? Well, it depends on how you want to construe that, but where the grounds are located. So it all depends on.
So do you mean by rule or by law?
No, rule of procedure.
Rule
because
of procedure.
The judge has to understand where your grounds are established in the rules of procedure. So
you have to have rule of procedure and the law to back it up. To back up your claim?
This is regarding making motions orally.
Okay. Oh, gotcha. Good.
Even when your written motions, like any motion, you have to do the notice of hearing. You have to tell the court you want to be heard and that you demand a hearing. Okay?
Right.
Then your motion is just a short little page thing. Your brief is where the law part comes in. But in the motion, you still have to put pursuant to this rule. Because you have to know, and a lot of times it's the code, the statute, and the rule that you're bringing this motion.
So you're talking like the Utah code, and then and then the civil rules of procedure. Correct?
No, you can make motions that are based off of statutes, but certain motions will require rules of procedure.
Okay.
Like motions for dismissal. Okay.
Okay.
There's no statute telling you how to make your motion for dismissals. That's in the rules of procedure. How to handle the case.
Okay.
That's like playing a game of chess. You have to know the rules of the game in order to successfully play the game. And that's what it is. It's rules of procedure to play the game of court.
Right.
You have to follow those rules. Whether you like them or not, use those things to your advantage because they are there for everybody to play by these rules.
Right.
And if somebody else isn't following those rules, you bust them on it.
Right.
Well, this isn't in accordance with the rule. You'll get a motion, your Rule 12B. If it's something in that motion isn't up to par with the rule, motion practice, you can ding them on that.
Right.
You can get their motion to dismiss because they're not following motion practice. They're not following the rules procedure.
Okay.
So from there, you always challenge jurisdiction.
Right.
And then once you challenge the jurisdiction, the burden of proof is moved to the other side, and they have to prove that they have jurisdiction. And if they can't, it's automatic. That case is done. It's toast. And you always want to, if you're on the defending side, you always want to make, well, how do I say this? It is a good idea to do with prejudice, because that means you can't refile.
Right.
You already had your chance. You messed up. Now you're done.
Right.
And you can't bring this up again, ever.
Right.
And, that's just the way due process of law works. You violate my right to due process, you lose immediately. Right here, right now, we're done. Bye. Have a nice day. And I'd also like to collect costs and fees for having to defend this frivolous act, or this frivolous claims.
Okay. So basically, I need to find, like, the Utah civil procedures, the rules.
Depending on what court you're in. If you're in a criminal court, you have to go off the criminal rules procedure. But yes, civil rules. Okay. Now, in Idaho, they have civil rules of procedure. They have family law rules of procedure. They have misdemeanor criminal rules. They have felony criminal rules of procedure.
Right.
So you have to, you really have to know what court you're in and what rules of procedure you're under. Okay.
Works for me. Okay. Well, thanks for your time, Kirk. I got to go hop in the house and get dinner done for the fam. So thank you for your help today, and I will talk to you later, sir.
Awesome. Thank you. It was great talking to you again.
Okay. See ya. Okay. Bye-bye.
Bye. Okay, so what Crystal was talking about there is, the procedures, which procedures you want to use. And those procedures are specific to your state, to your court, to your county, and sometimes even down to the city. Some cities will have their own rules of procedure for the particular court that you're going into. So that's something you will have to check into wherever you're at. My understanding is commonwealths are the ones that really break it down, clear down to the city rules of procedure for that particular court. But they do have to follow the state's rules of procedure. They can have other rules of procedure to deal with certain things within the city for that court. but none of those rules can be outside of the scope and authority of the rules of procedure set by the Supreme Court of the state. So when you have your case there and you make your motion to dismiss for lack of jurisdiction, it's the first thing we always do. Always challenge jurisdiction. So this is supposed to be done before you make a plea. It's in the form of demur. You're not pleading guilty. You're not pleading not guilty. It's in the, you're pleading. If you're going to say you're pleading, it's in the form of a demur. And basically what you're saying is, this isn't lawful. And I'm claiming my right to be free from being deprived of my life, my liberty, and my property without following common sense due process of law, the law of the land. Is there an affidavit? You know, I talk a lot about this criminal side of things because that's a lot of what I've studied over the last many years. So some of this procedure stuff is criminal type stuff, like motion to suppress. So you have evidence that's being admitted, and this actually applies to no matter what court you're in, the rules of evidence. That's another section of your rules that you will want to read is rules of evidence. And it's a separate set of rules because the rules on evidence are set as a standard across all courts. So each court doesn't have their own set of rules on evidence. Each state has one set of rules pertaining to evidence. So read those because it will amaze you at what the rules of evidence pertaining to your particular court will have. Like, hearsay may be admissible in this certain type of case and in this certain type of situation, in this certain type of hearing, but not in this one, and this one, and this one. So you have to know how to object to certain types of evidence that's going to be submitted and whether it follows the rules of evidence. In criminal, then no hearsay. Must have firsthand knowledge. If you've got anything that says, oh, well, so-and-so said, and we're using this as evidence, that's not firsthand knowledge. You can make an objection to that. You go through a motion hearing to suppress that evidence that's trying to be admitted as evidence, and you have a hearing on it. And you object to it being admitted as evidence because it's based on hearsay. And now the moving party has to prove that it's not hearsay. And if they can't prove that it's not hearsay, that it is actual truth, facts, backed with evidence, not just words, then it gets dismissed. They can't do that. That evidence gets thrown out and can't be used against you. This also has to happen in the very beginning of the case. Let's say they somehow make it through this jurisdiction. Let's say you even have proper grounds for dismissal for lack of jurisdiction. You make your claims, you give your oral argument, you let the judge rule against you, you move on to the next stage. That's an appealable issue. The judge acted outside their scope and authority by denying you and dismissing your motion to dismiss for lack of jurisdiction. They don't have the power to deny you rights or justice. One of those rights is due process of law. So you go to your suppression hearing. That's the next thing you go through is you try to suppress all the evidence that they have that they're trying to present against you. And what that does is it basically handicaps them, the moving party, from presenting evidence that could get you convicted or found guilty. But if you object to it and you get it thrown out, you leave them with hardly anything to go on when they thought that they had a right to a cause of action and they thought they had all this evidence against you. When it comes down to it, they don't, they're in trouble. They're going to start backpedaling, especially when you talk about criminal side of things, when the prosecutor takes a case that doesn't have substantial evidence to support the claims. From there, these are all pre-trial motions, and the latest one I haven't fully learned yet is the motion in limine. Again, it's actually the reverse of the evidence, is to limit you or me, I would say. It's the moving party to limit me from presenting evidence. It's the other side of the motion to suppress. It restricts me from presenting evidence that might be factual and things like past criminal history, interdealings with other people, that kind of stuff. Stuff that's not actually evidence that you committed the crime or that you committed this act prior to, it doesn't have anything to do with this particular act. So, it can't be used. So even we can do that one, motion in limine, to restrict them from using a past criminal record or past history of anything, because it doesn't have anything to do with the current charge and the right to a cause of action. And then from there you have your pretrial, which is where everybody basically comes together and says, okay, has everything been heard? What hasn't been heard? We need to hear it today. And are we prepared to go to trials? Everybody got their evidence in order, whatever's left that you're allowed to have. And then you proceed with trial by jury or trial by judge, depending on how you chose to go. And then if you have appealable decisions, anytime that you've tried to object to evidence or you've objected to the jurisdiction and you feel that those claims are valid, even though there was a hearing held and the judge denied, those are all appealable issues. And so your right to due process of law continues on to the appellate court. Then you have a whole new set of rules of procedure for the appellate court. You have to do the notice of appeal. You have to notify them that you're appealing within a certain amount of time. Most of the time it's 42 days. Then you have to file your brief, your memorandum of law, your points of authority. You have to make your motion for the copy of the transcripts, which have to be submitted to the appellate court. And then you're responsible for looking over that transcripts to make sure that everything is in there that you recall happening during your case. And if there's anything missing, you have to write an objection. Okay, hey, there's something missing here from this time to this time on this date. I recall this, and it's not there. The appellate court will send it down to the lower court and say, hey, where is this stuff? And you have to give it up. And you do interrogatories. That's one of the same thing with the criminal side, is you do interrogatories, and those are questions that you ask. You have a certain amount of questions you can ask, and that works both sides. Both sides get to ask basically discovery questions, and you get to basically interrogate. You're searching for info, evidence, and any of those words in there that they respond with, or lack of response, could be used against them. And that's what you're doing. You're digging up evidence. You're trying to trip people up, trying to get them to say something that, they have to admit to a certain question or specific question that you're asking. So anyway, on the appeal, yes, you do interrogatories and all that good stuff, and that all goes through there, and they make their decision. That's a 3-panel judge that goes through all of that. And this is what's important about in the record and on the record. In the record is putting your paperwork in, and on the record is making your oral arguments. I don't care what the judge rules. I don't care what the judge says. You make your statements on the record, in and on the record. So when those transcripts go up to the appellate court's going to read those, because it'll be transcribed into words, from the audio to words, and you're going to be able to make references to those transcripts. Well, at this certain date and time, line number, blah, 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 within the transcripts, line 49 says here, the officer testified to this. Well, in his police report, it says this. Two totally different things. There's many different things that you want to look for in your transcripts, but those things are that you want to bring up as grounds for the appeal, to have the appellate court overturn what the lower court has decided. But if you don't make your arguments on the record, it's not going to be in the transcripts. And especially if you try to make your arguments, and the judge denies it, even for you even to speak, that's a judge not acting in good behavior, as long as it's properly before the court. I mean, you can't go in for a motion hearing based on one thing and then try to talk about subject matter out of another thing. It's two different types of hearings, and you can't talk about both things at the same time. You have to stick to specifically what the motion is about, which kind of sucks because it's happened to me, but I still got through it. Where are we at? 58. And then, if you don't like the decision of the appellate court, due process of law continues on, and you go to the Supreme Court of whatever state you're in. And then, again, everything is all over. Start all over again. Transcripts, copy the transcripts, go through the transcripts. All of that gets submitted to the Supreme Court. And part of what goes in your deal there, even in the appellate court, is you have to put in there that you want to make oral arguments. You always want to make your oral arguments, unless your paperwork is so beautiful, which it can be. Let's say you're not a really good speaker in front of the judge. Even I still have a little bit of issue with it. But I can tell you, back when I first started getting in front of a judge, I couldn't hardly even talk. But as I've been doing this more and more, it gets easier, because they're just people. And if you have that mindset that they're just people, they're actually there to listen to you when it's your turn to talk. Don't ever talk out of turn, because that's not good. The judge isn't going to find favor in you when you start disrupting him, her, and the court. You know, you might even get warned about that you could be found in contempt of court for disrupting the court. But all that just follows that procedure. Appellate court, Supreme Court, all of your objections. If your paperwork's perfect, you don't need to make oral arguments, great. But if you want to make your oral arguments, make sure that is in your initial motion to appeal, notice of appeal. Your motion to appeal, you're going to put in there that you want to make oral arguments. Same thing with the Supreme Court. When you motion it up to the Supreme Court, you're going to want to put in your paperwork that you want to make oral arguments. Again, so that you can make your statements. And that's pretty much your state court stuff. And there's quite a bit more to it. I just kind of summarized it. But your rules of procedure will tell you, and it tells you everything that you can and can't do, what the motion is, what rule it falls under, what grounds you can make. It's all in the rules of procedure. You just have to read it. You have to take the time to read it. So back to the false arrest and false imprisonment. False imprisonment is the name of the category for those torts that unlawfully deprive or interfere with the liberty of a person. Under this category, the unlawful arrest is the most common type of wrong committed. Another common way in which a wrong of this nature occurs is by the unlawful detention of a person in a room, jail, or other location. Definitions of false imprisonment usually come from unlawful restraints of this nature. False imprisonment has been well defined to be a trespass committed by one man against the person of another by unlawfully arresting him and detaining him without any legal authority. That's number 11. That's Regal versus High Grade Steel Company, 47 Federal Supplemental, page 290, 294, 1942 case. The law sets such a high value upon the liberty of the citizen that even an attempt to unlawfully arrest is esteemed a great provocation. All the authorities agree that an arrest may be made either with or without any physical force or actual touching of the officer. Imagine that. They don't even have to force you to do anything or touch you, and it's still considered an unlawful arrest. Thus, any illegal restraint of one's personal liberty by the act of another gives that person a cause of action for false imprisonment against the one causing the illegal restraint. Prima facie, any restraint put by fear or force is unlawful. Period. So the officer coming to your door doesn't necessarily deprive you of your liberty or anything at that particular point, without a warrant, obviously, but could, is the second that you tell them to get off your property and they don't. Now we're getting into false imprisonment, false arrests, unlawful detainer, detaining you unlawfully, because detain and arrest are synonymous. So this goes in accordance with Child Protective Services, or whatever it's called in your state. There is no proper delegation of authority for someone from an agency known as Child Protective Services or Human Health Services or whatever it's called, even though their policy or the administrative law says that they can. The law of the land dictates otherwise. No man has the right to come onto your property and deprive you of your life, your liberty, or your property without due process of law, following the law of the land. Now let's say they do have an affidavit saying that you did something to your children. CPS still does not have the power to come onto your property and take your children. Where is the warrant? They're going to seize your children, and that's another thing is if you're being accused of a crime, which would be regarding the best interest of the child, there's actually a strict scrutiny test that this best interest of the child falls under, because we're talking about a governmental compelling interest. And anytime you have the term governmental compelling interest, there will always be a strict scrutiny test that it must pass. And when we're talking about the best interest of the child, it has to have to do with food, clothing, shelter, and actual abuse. Now, the abuse part, that would be criminal in nature. That cannot be construed as civil in nature. So there again, lack of jurisdiction because the court does not have competent subject matter jurisdiction to hear criminal claims of abuse in a civil court. Now, you can be sued civilly for those deprivations of rights or the rights of abuse, violations of rights to be free from being abused, and they better have evidence to show that you did abuse your child. But the key here is, who do you remove from the home? Do you remove the criminal or do you remove the child? It would be completely illogical to remove the child from their home when they have done nothing wrong. So this is something that would fall under jurisdiction because they don't have the jurisdiction, first of all, to take your children. Second, they don't have the power to claim that you're abusing your children and take your children. They have to take the criminal and follow the law of the land. Take that affidavit of truth, signed under penalty of perjury, and take it to the prosecutor. The prosecutor is supposed to present that to a judge or a grand jury if it's for a felony. That's part of the Fifth Amendment. Actually, no, it would be, I believe it's Sixth. Maybe it's Fifth. Either way, that affidavit has to be there, and they have to follow proper procedure, and they're not. They are not following that procedure clear across this land and all the way around the world. And again, law of the land, these are basic human being rights. Rights as law. As they are. So when they do that, that's a lack of jurisdiction. They had no cause of action. They had no right to a cause of action, and they didn't follow the law of the land. So you bust them on it. But if you don't file your paperwork and a motion to dismiss for lack of jurisdiction, for failure to state a cause of action for which relief can be granted, stating that cause of action has to have an affidavit. So even if the CPS worker wants to claim that they have a right to a cause of action, where's your affidavit? You have firsthand knowledge that this actually happened? No. Well, then what are you doing? That's not lawful for you to do that. You have to call them on it right from the beginning of the case. You have to file your paperwork, notice of hearing, file the motion for dismissal. You want to be heard. You get in there, you get heard. But if you don't do that, nothing's going to happen. They're going to walk all over you. This is what's key here is knowing what your rights are, where to find them in law, and how to effectively defend them. Because if you don't know this stuff before it happens, you're going to get screwed. Even with an attorney, because their job isn't to defend you. Their job is to perpetuate their racketeering scheme by dragging your case out, and can you pay more money, and then you got to go do this, you got to go do that, more money this, more money that, and while everybody else gets their pockets lined with your money, you go in debt and lose your house, you lose your car, you lose everything else. It's not like country western music, you can't play it backwards and get your dog back and get your house back. A little sarcasm there. But you have to be prepared for this stuff. You have to have this in your mind and be educated and be prepared for this, because this is happening all over the world on a daily basis, hourly basis, minute basis, if you want to include the entire world. This is happening right now. There's another one. And another one. And the only way we're going to stop this is by claiming our rights, exercising our rights, and defending our rights as law. You're in violation of the law. You violated due process of law. You violated the law of the land. I claim usurpation of power. I claim violation of the right to due process of law under the 4th, 5th, and 6th Amendments to the Constitution. And then you can claim the 14th Amendment, too, if you're going to go that route. You're going into federal court. That's the next step. That's part of due process. You have the right to file your tort claims under Title 42, 1983. That's Section 1983. Civil rights violations. What I do recommend is when you do have this is go to the Department of Justice website. Crystal, this is something I told her about. She went and did it. And she shared with us before. It was like a half hour. Took her like a half hour to do it. They responded with back within 2 weeks and told her, we don't have enough complaints on this particular topic to start an investigation. So, which would behoove us to start making these complaints through the Department of Justice on their website. Takes you about a half an hour to fill that out online. And that's the start of your Title 42. That can be the start of your Title 42. Is you make your claims through there, and basically what they say is, we don't have enough complaints here to start an investigation, but we give you permission to file your tort claims, your Title 42. So the Department of Justice actually gave Crystal permission to do this, which is going to be kind of interesting to hear how her case goes. Because she did go through the Department of Justice, and they said, yep, go ahead. We're going to let you do that. No questions. So we have a couple of people. I don't know if anybody has any questions, but if you have a question, you can press 1 on your keypad, and it'll indicate to me you have a question. If you do, then I'll bring it. There we go. 2717. Who are we talking to?
Hi, this is Christine Alden.
Hello. How are you?
Good. I'm good. How are you doing?
Pretty good. Did you have a question for us?
Yes, I do. I'm wondering about when you sign a waiver of your right to counsel, do you have the right to later hire an attorney? I've had forced counsel on me, and I am presenting myself as my 6th attorney. And I did state on the record that I waived my right to counsel. However, I reserved my right to hire counsel at a later date.
That's kind of a tricky situation, and I don't have a whole lot of experience with that particular part. So I would think if you waived your right to see, this is the problem I have with that, is the Constitution says you have the right to assistance of counsel. Nowhere does it say that you have the right to be represented by an attorney. But they have construed it over and over that you have the right to have someone represent you, which is an attorney who attorneys you.
Right.
Now, Kurt, even if you waive that right, I would still think that you have the right to hire an attorney, and your attorney will do a notice of appearance. And I really don't think that the judge would not allow it.
Right.
Well, Kurt.
I know when...
Kurt, we did that with Penny's case, and we filed a motion to redact all her signatures because she didn't know what she was doing. The other question is here, if you've had 6 public pretenders, they're only allowed to give you 3 before you have a mistrial, from what I understand. So you might want to look up those 2 things.
Oh, wow, that's good to know. They also forced a guardian ad litem over me. They have one for my children, of course, but they forced one over me, even without a petition for incompetency, and forced me to undergo a multiple disciplinary evaluation, which I passed with flying colors, and then they finally acknowledged my right to present myself, because that's why they continually forced counsel on me, was because I kept motioning to enter pro se, and it scared them. They forced me in chambers and then forced counsel on me, and I told him if he attempted to represent me without my consent that I would sue him. So they withdrew him, and then they went right back into chambers and came out and forced him on me. The judge ordered him to be my attorney. So they denied my right to present myself. But now I've been doing this for probably 6 months, and things are finally turning around because I'm the only one that's actually fighting for myself and my children. And now I'm getting to the point where I feel I really need an attorney, because time has been dragged out, and I have to get my children back home. So.
And the other thing is, with Kurt and myself, is we always tell you file pro per. You need to look up, there's one word difference between pro se and pro per. If you look up the dictionary, there's one word difference. One says as yourself, and one says for yourself. And in Texas, pro se is required to act as an attorney. They're under the same scrutiny, even though the Supreme Court has denied that.
They try to construe.
My parents always
that you have to be held to the same standard as a bar attorney, and that's not true. But you can go ahead and make that argument. You object to that on the record as an appealable issue.
Okay.
Are you sure you want an attorney? Because it sounds like you were actually doing pretty good, and they've been trying to pull some stops on you to try to keep you from tearing them up in court. And, I mean, I don't know exactly where you're at in your case and what you have filed.
I have filed, oh my goodness, probably 20 motions. 16 of them they didn't recognize because I had forced counsel over me, so they weren't required to recognize them. I had no defensive motions. I was refused to allow to testify. My attorneys refused to enter my evidence. I mean, I was just blackballed, and I mean, I've entered what's called as a mandatory judicial notice, which is Rule 201 DEF, and I'd like to share this with everyone because this is how you get in evidence without it being under discretionary ruling. They cannot object to it. The defense can't object to it. I'm sorry, the plaintiff can't object to it, and the judge can't object to it. It's a mandatory judicial notice. And you attach it with adoption.
What rule of procedure is this?
Rule 201 D, E, and F. And along with that, you're going to want to file a rule.
Is this federal rules of procedure?
I believe it's federal rules of procedure, yes. 201 DEF, and it comes along with Rule 10C, and that's adoption by reference. And so you have your cover sheet, you have your mandatory judicial notice, you attach your evidence, which you typically want it to be self-authenticating, with a logo or a document or a doctor's signature or someone's signature and a letterhead, so it's authenticatable by whoever the evidence came from, and that's Rule 10C, and you want to attach it with an affidavit. It must come along with an affidavit, notarized, and they can't refute your evidence that way, and it took me nearly a year to find out how to get evidence in because everything was completely suppressed by the attorneys who were supposed to defend me. So that's how to get evidence in, and I want to share that with the world because it's a total scandal that it's not known, you know. But I was able to get a lot of
documents
in. Yes, mandatory judicial notice. And it will piss them off. You know, they don't like it because now you have the grounds for appeal. So it was just imminent that I got that in there. But now I'm to the point where I'm trying to file for an increase of visitation as well as custody. And I feel like I need an attorney to do that because I've never filed these motions before. I unfortunately was deprived of seeing my oldest son for 10 months and my youngest son for more than 4 months. And because I didn't see my children, that would have been held against me as far as if they wanted to pursue a TPR. So now, since I've signed their paperwork, I'm able to have visits with my children, weekly visits. And the therapist that DSS has sent me to has said there's no reason for your youngest son to have been taken, and my oldest son, all he needed was counseling. I was found for neglect for not opening the door just to let them take my child. And then my oldest son, they found me for neglect for lawfully homeschooling, which I proved with mandatory judicial notice that I was fully compliant with the state law. So I'm able to get in appeals if they ever move to that, but they're trying to prevent increased visitations, which reunification is court ordered. However, I know CPS has no intentions on giving me my children back, or they wouldn't have taken them in the first place. So I also entered that I have no criminal record. Well, this is an epidemic that's
worldwide, so do not feel alone that this has happened to you.
Yeah, they try to call me crazy.
Especially when CPS gets involved.
Yeah, they wouldn't let me present myself. They tried to declare me incompetent, denying their own state statutes that state that there has to be a petition for incompetency before the court, which there wasn't. So they just tried to deflect me from defending myself in every manner. And false testimony, perjury, I mean, you name it. The affidavits weren't signed under penalty of perjury. They were signed under oath from people that I still have never met and have never, been to my home. My social worker's never been to my home. They just came in like a SWAT team, and they pulled 3 guns to my head with my arms in the air and my child behind me, and put our lives in danger when nobody was ever endangered. So, I can't trust them. But, I've turned everything around. Instead of my legal battle, I've said, look, I want to work with DSS. I want to work with the court. I lay down my proverbial sword here. I want to do whatever I need to do to get my children back. And since I did that pro se, things have turned around. They've given me visitation, but they're still clinging on to my children and, making lies and saying I don't have a bond with my child or I need to repair my relationship, which is untrue. And they're also claiming they've made reasonable efforts for reunification, which is not true because I've been asking for counseling with my oldest son for a year and they haven't provided it. I was gagged from the filing any paperwork. I was gagged from the clerk of courts. I was gagged from DSS. I was gagged from the guardian ad litem, gagged from my children, gagged from their school, gagged from their therapist. And I've gotten rid of every single gag order except for the one with the schools. So I've turned things around immensely, but they're at the point where they're trying to cling to my children. And in 2 months, it's 15 months, and they may make a motion to TPR me, and the judge can order DSS cease reunification efforts. But I really have to get a lot of legal work in order so that I can, fight TPR because they haven't made reasonable efforts. Even their therapist said there's no reason my son should have been taken, and she recommends weekend overnight visits. So it's just been a nightmare, and I feel I really need a strong legal arm, but it's hard finding someone you can trust. So it's sad.
Well, there are paralegals out there that you can hire to draft your paperwork.
And that's a good idea.
You can still make your arguments.
Yeah, and I have no problem speaking
it's really
in court.
about the paperwork, which even myself, I struggle with doing the paperwork. But I'll tell you what, I can make an oral argument like you'd not believe.
Exactly.
So that's my weakest point in this whole thing is my paperwork. But I'm going to be learning from a very knowledgeable man how to do the paralegal stuff. So that would be something that I would look into if I was you, is look for a paralegal to draft your paperwork and make sure that it's, because that's what a paralegal does. That's what they know how to do, is make sure that paperwork is perfect to be filed with that particular court in that particular state. So if you can do that, and they're not as expensive as an attorney, and not only that, you get to make your oral arguments. And so you work with the paralegal drafts your paperwork. If you work together on it, you're going to know what's in it. Then you can read it. And if you have to, you can read right from your paperwork in your oral arguments.
Yeah, I've done that. Yeah, I always have my brief ready. I always have my motions ready. I file them at the last minute because that's the game they play on me. And you don't want to give them time to find a loophole, which is their same tactic. It's always in the 12th hour. So, but I have literally till Friday to draft my motions for custody and increased visitations because they're not granting me that, even though the judge said that they can do that without a court order. So, DSS has the authority to give you your children back, on their own recognizance. And, I just don't see them doing this. They are all about the numbers, they don't care about the people. They could give a rat's about my children.
Right. What they care about is that Title 4D funding, getting that money out of your Social Security and getting that reimbursement to the state, even though it's all taxpayers' money. You pay taxes at the state level, and then you pay taxes into your Social Security, and they're taking that too. So you're being double taxed for having your child taken away from you.
Right, and I'm paying to defend it.
And then, of course, then they want you to reimburse. If you do get your children back, if they were in foster care or whatever, they're going to want you to reimburse them. Before you get your children back, you need to reimburse us for everything. Well, wait a minute. You already took tax dollars to pay for this, and you took Social Security funds to reimburse those tax dollars that up to 66% of what you spend in state tax dollars.
I never signed an indigency form, which gives them the right to seize my assets and seize, money and whatever, and repayment for their court-appointed liars. And, I'll never sign that.
Right. So,
they take my children in my house.
In the beginning of your case, you said that they came in and just took your kids at gunpoint and that kind of stuff. How long ago was this?
Well, my oldest son actually was taken 6 months to the day from my youngest son because of Title IV funding. If you look in the DHHS manual, it states that, there can't be a juvenile in the home after 6 months. It states 6 months in 10 different places at least. And they took my youngest son 6 months to the day. And I know it was for Title IV funding, and obviously they didn't have a reason. I found out what the reason was. That not only 2 is worth more than none, but it's because of the Title IV funding that they wanted to continue receiving. And, if you have a child still in the home, it proves that you're fit.
They had no real cause of action.
Well, this is the story. With my oldest son, of course I have 2 autistic boys. My oldest son, I was homeschooling both of them, and my oldest son got into, we'll just say, indecencies online, and I found out about them, and I asked him for a tablet that he was accessing that on while I was sleeping, and he refused to tell me where it was, and it escalated, and I threatened to ground him. He said he didn't care. I threatened to ground him for a week. He said he didn't care. And I said, well, get your butt over here. And I slapped my legs and I said, you're going to get a spanking if you don't give it to me. and he ran downstairs, and I went after him, and he pulled a knife on me in the kitchen, a small rounded knife, and he was scared of a spanking, and he told me to get back. Well, he ended up calling the police and getting arrested himself for assault with a deadly weapon. And basically, he went to a detention center, then straight to a foster care, and that's how it started. And then they came and took my youngest son 6 months later. So, but the funny thing is in North Carolina.
So again, how long ago was this?
12 months ago and 6 months ago.
Okay.
So my clock is ticking, and that's why I'm
grounds that you can go under. It's called fraud upon the court, and there's actually no statute of limitations on fraud upon the court. You take this as an independent action, not in the same court that you're in now. As an independent action, you file in the civil court a motion to vacate this whole entire case for fraud upon the court. And the fraud is they had no lawful authority to take your children. And what that will do is it will make this civil court make a decision whether or not they followed due process of law. And that is what this episode is about, is due process of law. And if you were listening earlier, there is a process that is due to make an arrest. And did they follow that process? No, it doesn't sound like they did. So that means there's fraud on the court.
Right. There was no warrant. The DSS attorney pulled me in the back chambers and said, look here, you're going to be found, if you want to see your children, you're going to be found for neglect for not opening the door to let the police in. And I said, well, obviously I was protecting my children from unlawful seizure. And, he said, I don't care. You're going to have to consent to neglect for not opening the door. And I said, well, fine. And I didn't sign anything, but, I consented to neglect for not opening the door. But in all actuality, that's my Fourth Amendment right and my First Amendment, freedom of association and freedom not to associate. But my whole argument, and I've raised this in court, is that had I allowed my son to access pornography, I would have been found for child abuse for dissemination of sexually explicit material to a minor child, or permitting sexually explicit material to a minor child. So I'm like, are you finding me for neglect for, how can I be found for neglect for upholding the law, when if I didn't uphold the law, I would have been found for abuse? So I have a massive case with both my children, So, I mean, I've thought about federal court and, raising a lawsuit in federal court to get them to give me back my children. But I'm trying the method with working with them, and, everybody says it doesn't work, but it's gradually working. At least I'm seeing my children, because they would use that against me too. So I'm damned if I do and damned if I don't. And I need someone who's got experience to say, hey, this is what you do. I will press these charges. We'll, bring it in a federal lawsuit, a constitutional lawsuit. There's also the aspect of my children being disabled, and there's more funding for them. And that's disability discrimination. They put in the paperwork, my son is autistic. And I'm like, how is that a crime? It's in the judge's notes. And so I'm wondering, when you said to file charges for fraud, is that criminal charges in criminal court that I'm filing a fraud against the court? Or how would I go about doing that?
What happens if you go under fraud? At first, it's civil, but you can make your tort claims, which is the criminal side of things, in your Title 42 under 1983 for violations of your civil rights, your 4th, 5th, and 6th Amendment. Constitutionally protected rights. Your civil rights are protected. That's due process of law. Now, it's both civil rights violation, and there's criminal complaints that are claims within the civil lawsuit. Now what happens is you go in and it gets adjudicated that, yes, they violated your civil rights by violating due process of law, which creates criminal acts, which is what I was just reading there from the treaties on arrest and false imprisonment.
Okay.
They unlawfully seized your child, both of your children. That's fraud upon the court.
Yes, they did.
Nobody questioned
did.
it in the beginning, but when you take it to federal court, then fraud is under Rule 60, and it's D as in Delta,
60B.
not Bravo.
Yes.
Not Bravo. A lot of people, Rule 60B, Rule 60B. No. If you read all of Rule 60 and you go to D, it talks about how fraud can be made at any time, can be entertained at any time.
Okay.
And that also includes jurisdictional issues.
Right. Now, I've filed a 60B, a motion to vacate, and I've filed a motion to dismiss. I've filed so many motions, I'm blue in the face. I have 2 filing cabinets full. They said they've never seen a parent fight this hard for their children. And I'm like, well, hello, nice to meet you.
Right.
The other thing, well, Kurt, is this might be a good case. One. This might be a good case under, and this has nothing to do with the courts. It has nothing to do with anything. It's filing a complaint to the Secretary of Treasury, and it's Title 42 USC 674. Because you can make them lose 0.5% of the whole state's funding. That may not be a lot to you when you say 0.5%, but you're talking the whole state. You don't lose 0.5% of your funding. In your case, you make them lose 0.5% of funding for the whole state for every violation. And you can file every 6 months.
Wow. Yeah, I think every parent should do that. We could take the system down.
That's Title 40. Correct. Yeah, well, even if you had 100, you've already taken 50% of their funding.
All right, so,
but that's
Chris,
Title 42,
are you on Facebook?
640,
yes, I am.
74.
And are we friends on Facebook?
I'm friends with Ted Fogg, so. No, we're not, but I sent you a request.
Okay, please do. We'll meet. We can talk some more later. I'd like to take this other question we have.
Sure. Thank you so much.
Thank you for sharing.
Absolutely. Y'all have a great evening.
Thank you. All right, we have 5324. Who are we talking to?
This would be Sarah, also in North Carolina.
Awesome. Welcome to the show, Sarah. Did you have a question for us?
Yes, I do. I heard that you guys are talking about the civil small claims, a little bit about my case. Tomorrow marks the 1-year anniversary of the kidnapping of my children from my county. They fast-tracked me once I went pro se and started standing up for myself. I filed about 11 mandatory judicial notices, had a lawyer on the TPR hearing, which they did about 6 months. They're actually supposed to wait for a year in North Carolina before they start TPR proceedings. But they've literally thrown me in jail several times. I'm gagged in Superior and District Court. It's been a rough road this last year. I don't even know where my children are. But I figure it would be lovely for tomorrow to file these civil suits, proceedings against them. So I'm going to go do that. But I'm curious, can I file several civil proceedings at once for each title offense, or do I file them separately?
If you're claiming civil rights violations, that would be under Title 42, Section 1983. That's your civil rights section.
Right.
And you make your claims under. Huh?
Yeah, I will be doing one of those, but I was told you can't. It's probably not good to mix the criminal part with it. So somebody was telling me about the small claims. See, what it's called is tort claims.
Tort claims are criminal violations, but you're not in a criminal court. But the civil court, under Title 42, 1983, you make your tort claims along with your civil rights violations claims. And what happens is the civil court adjudicates that and says, yep, your rights were violated. Your civil rights were violated. They violated due process law, which is indicative of criminal, that's crime. That's criminal crime. That's felony under Title 18, Section 241 and 242, depending on which one is applicable to your case. So that's the tort claims side. So once it gets adjudicated, all of those criminal claims become eligible to go in front of the Attorney General for the state, and they will prosecute all of those that are involved.
So when I file, because I was going to do was it 1983? How do I determine what civil lawsuit is best for my case?
Well, if they violated your civil rights, any of the, if you read Title 42, 1983, it gives you the list of all your grounds of all of the civil rights violations. Those are your grounds for bringing suit. And then you just make your claims. Each and every time there's a violation, they're worth up to, clear up to $500,000 if it's an agency. So CPS as an agency is liable up to $500,000 per violation. If they violate due process of law, and they're going to claim that they're in a position of authority to do what they did, they're going to have to back that up. And they can't. The second they start quoting their own policy, no, that policy is unlawful. It's in violation of the Constitution. It's in violation of the supreme law of the land. It's in violation of due process of law. Your policy is hereby abolished. But you have to make a different challenge under, I believe it's Rule 4.1, or is it 5.1, one of the two. I think it's 5.1, where a statute is in conflict with the supreme law of the land, which is part of Article 6, Clause 2, where it says, anything in the Constitution or laws of a state to the contrary are notwithstanding. So that's how you attack an unlawful statute, rule, regulation, or policy within a state corporation, or state agency. Well, our policy says we can do this. Well, the supreme law of the land and due process of law says you can't. So unless you go that route, and this is part of your lawsuit, it's seeking declaratory judgment. You want the federal government to declare that the statute, rule, regulation, or policy of that state is in violation of the supreme law of the land. And like Marbury versus Madison says, anything that comes in conflict with the supreme law of the land is null and void from its inception, not from the date that you go to court and brand it as unconstitutional. The Supreme Court justice is going to look at that and go, yep, that policy is clearly in violation of your constitutionally protected civil rights to due process of law. And we hereby declare it unconstitutional. And that makes all of your claims valid, both civil and criminal. So now that part gets adjudicated separately from the civil lawsuit. So it's a separate claim, but it's filed at the same time. Because
okay.
That court can't determine whether it is unconstitutional or not. It has to be brought under Rules of Procedure 5.1, declaratory judgment, and that's handled by a separate court. But it's still tied to your case. So when the declaratory judgment comes back, then the other judges in your civil rights violations case under Title 42 will adjudicate it in accordance with the declaratory judgment. Okay, this has been declared unconstitutional. Therefore, their argument that what they did was, well, we had good faith reliance. We had good faith reliance, Your Honor. Well, the way you acted was in violation of the supreme law of the land. So the federal court on your civil case is going to take that into consideration when they make their assessment and hand down their opinions and rule in your favor or rule, not in your favor, depending how your paperwork is and how you make your arguments. So you have to be real careful how you do all that stuff as well. But if you make your arguments right and your paperwork's good, more than likely they're going to rule in your favor.
Do you recommend going pro se in a civil suit if a parent believes that they could do it with enough research and study?
As far as I'm hearing around the block here is that the federal court doesn't really like people bringing their own Title 42 claims without an attorney. So you could ask around to see if you can find one, and if you can't find one that'll help you, then do it yourself. And again, I'll recommend that people get at least a paralegal that knows how to draft the paperwork. If you can't figure it out yourself, hire a paralegal to do your paperwork, so that way you have a lot better chance of your paperwork going through without it getting, kicked out because something's not right in your paperwork.
That would make sense.
Yep.
Well, I appreciate you answering those questions. It's been a long, hard road for me. We have a really high rate of unconstitutional seizure in North Carolina. And mine also happened to be no petition, no warrant, didn't even know the social worker's name, didn't know where my children were for 2 days, and law enforcement threat of being jailed if I didn't let them take my children.
And again, trust me, it's not just your state. It's not in just your city, your county. This is all around the world. This is a grand scheme to break our country down, break our families down clear across the world. It's a sick racketeering scheme, a child pedophilia ring. I mean, it's bad.
Oh yeah.
But this is something that we can do to stop this. We need to file our paperwork and we need to make our arguments. And when they don't grant our motions for dismissal or, to suppress evidence that's either illegally obtained, fruits of a poisonous tree, or playing out hearsay lies, hey, I want this evidence squashed because it's hearsay. It's not true. They have no evidence. There's no truth, facts, and evidence to back this up. And the judge dismisses it anyway. Well, that's an appealable issue. The second the judge denies what is wrong and is not true, and they're allowing that evidence to deprive you of your other rights because of that unlawful evidence, you file your appeal. You appeal that judge's decision. You have that right. That's part of due process. And you can take it all the way to the Supreme Court of your state.
On that, I have one last question if you're willing to answer it. It's about appeals.
Sure.
I have filed notices of appeals as a pro se litigant, and I have even gone to the Court of Appeals to try to figure out how to appeal because I've had 2 ineffective counsels, which were reported as ineffective counsel. And I'm trying to appeal my TPR, but I've got even notice for appeal for habeas corpus. They denied habeas corpus for my kids. If they don't assign me counsel this time, because my notice finally got to the appellate office after trying to appeal things for the last 11 months, what do I do if they're not going to assign me an appellate attorney? I literally prepared my underlying case for appeals court because I studied appeals cases the entire time the TPR hearing was going on, just so I'd be ready for appeals. But, I mean, it's not going to work if I don't actually get in my appeal.
So you filed for an appeal, and the appellate court denied?
It didn't even get to the appellate court. My county corruptly stopped all of my notices from going to an appellate office. And this one I threw a fit and in the TPR, I threw a fit, and it finally got to the appellate office for TPR because I tried appealing adjudication. I tried appealing the cessation of reunification plan. I gave notice also for the habeas corpus. And they didn't do anything with my appeals. They didn't make it to the appeals offices.
But didn't you file it with the appeals office?
Oh, I filed them. Yeah, I filed them. I got copies of it and everything of the file stamps, but they never made it to the appeals offices. My situation's very corrupt. I'm blacklisted in my county.
Yeah, it's what happens when you actually know what you're doing and know what you're talking about, and you're better than an attorney because you'll actually, you know the facts of your case better than anyone else. And attorneys don't want to take on cases like this. They just want to extract money. So,
my biggest fear is that it doesn't actually make it in.
Take copies of this stuff that's been file stamped as received from the clerk of the court, and send copies of it to your Supreme Court justices and say, what's going on here? You're the overseer of all these other courts, and why are these judges or clerks of the court not filing my paperwork? I filed them. Here's a file stamp. Why am I not receiving due process? That's also another lawsuit that you could file. That's also a deprivation of due process of law.
Oh, yeah. My case
you have the right to an appeal.
Yeah, I do. I've had a right to a lot of things.
That would be a separate Title 42 case. That's a denial of, just in that particular point right there, that you filed your paperwork, you've got it. The clerk of the court's file stamped it, and nothing happened?
Yep.
Well,
and I've got my own copy.
Accountable for that.
Yeah. Because I believe my case would have stopped at adjudication with the things that were filed and the evidence that was filed, but my lawyer at the time refused to, and so I went all the way to the Court of Appeals in Raleigh. They sent me back to the clerk of courts, who sent me back to my lawyer, and I self-taught and learned online that I need to file the notice in so many days after the written order. But by then I'm verbally sanctioned not to see my files, not to read my files, not to get copies of my files. I basically could, and then this last hearing before the TPR, they said I couldn't even file anything. I'm sanctioned against filing anything. They really locked me up, in other words.
Hey, go ahead and friend me. This is Randall. I have the Baskin case down there that will help you with that gag order crap.
That would be great. Because my Superior Court case literally has no end. I have a right to a speedy trial. When they threw me in jail with no judge's order, I habeas corpus myself out. I got in front of a Superior Court judge, and he said, I don't have an order to have you in jail, and I have a habeas corpus. What kind of threat are you to the community? I said, I've never been to jail before, CPS. I'm a family rights advocate. I'm involved in church. I don't have a criminal background. He said, that's enough. I don't know why she's in here. And when I came up before a Superior Court judge again, they gave me a trial de novo instead of a habeas corpus trial. And they continued my that hearing endlessly. And I asked the lawyer on that case why they did that, and he said it's because of who the judge is, the district court judge, the one that threw me in there. She threw me in there for asking for representation when she tried me for contempt for the gag order.
Yeah, that's fine. That's no big deal. I guess Kurt might have got I think he got dropped. But anyway, this is Randall Stone. Tag me. Do you know Randy Davis?
Yes, I do.
Has Randy given you any, because he's got the same thing going on in North Carolina with his case?
Yeah, he's been very busy helping a lot of families, but since it's a little bit harder for him to get over here to help me, because I have been able to help myself somewhat, It's just I got so bogged down with all that other stuff.
Yeah, but I would say the Baskin case that we have out of Georgia is going to definitely help you in the gag orders.
That'd be great.
So, anyway,
thank you for using Blog Talk Radio. Goodbye.
Hello. So I guess they're really strict on Blog Talk with the times. This is Ted Fogg, by the way. I wasn't expecting it to just cut off like that. So my connection to them is gone. I don't know if you're listening on Blog Talk, if you can still hear them or not, but I'm dialed right into the show, and you're hearing it just like if you were calling into the show, and what you just heard, the show ending, that's the end of it, I guess. Sorry, Stephen Ball, I know you wanted to call in. That would have been a pleasure to hear you. I can't speak for Randall or Kirk, so I don't want to answer anybody's questions, but that's just amazing. I'm really excited to be able to bring his show to you guys. Because Kirk came on the show when it was still called the Million Parent March live, and every single show I had, he would be either calling in, and he was a great call-in guest, by the way, and he's always commenting, and you can tell why. He really knows his stuff, and listening to him on his own show where he can be free to completely express himself really shows that, and he definitely shines. It's incredible. He's a wealth of knowledge, and I'm glad he's doing this to spread his knowledge. And he's not an attorney. I believe he has a disclaimer at the beginning of his show that this is just for quote entertainment purposes only. He's not giving specific legal advice because that is technically against the law. He is just giving you all information on an entertainment basis, I guess is the way to say it. So he's not liable for anything. I want to make that perfectly clear for him now that, there's almost 800 of you guys watching or checked it out. And there's 200 comments for him to go through. And, he's also on YouTube as well, under the March.us YouTube channel, and Twitter with the same name. And, shout out to Randy Davis and Future of Our Children Radio Network for hosting all these shows. There's a lot of people doing shows through this network, and, including Far From Normal tomorrow. So I'm going to let you guys go. I don't have Zoom going for this show. Otherwise, I would get Kirk on that way. I'll have to set that up for him. So if this happens again, he can go over and continue answering your questions, because I know you guys don't want to stop listening. It was very informative, and I can't wait until next Monday. Law for Dummies with Kirk Pendergrass. And Randall Stone, I guess. He was able to jump in at the last minute there. So I'm going to, usually I do my community conference call to action at this same time. And the reason why I'm not is because I wanted to bring you guys this show, which is probably way more informative than a call to action. But I have a couple of things, so I'm going to stop this broadcast and give you the call to action in just a few minutes as soon as I set it up. There's just going over a couple of events and a surgery in one individual's life that I want to let everybody know about. So, thank you, Kirk. That was an amazing show. Not your first one, of course, but the first one broadcast live on Facebook, Twitter, and YouTube. Thank you, everybody, for watching live. I see you liking it, Susan. Susan Estillo is always there, and Rebecca is always there watching no matter what. I really appreciate it. Have a great night, guys. Love you.